The Supreme Court, just 6 blocks from where I'm sitting right here in Washington, D.C., the Supreme Court, in this incredible ruling, AT&T versus Concepcion, just may have changed once again, as they did with Citizens United, the course of America's future. At least it looks that way to me. I'm not a lawyer, though, and I don't make my living doing this kind of stuff. Mike Papantonio, one of the most brilliant guys in America and one of the best attorneys out there, and the co-host of the Ring of Fire radio show, ringofireradio.com is their website. He does know this stuff, and he is with us. Hey, Mike, welcome.
Tom, how are you?
Great to have you with us, Pap.
Yeah.
Tell me, I read much of the decision. I read all of the dissent by Breyer. Right. And in Breyer's dissent, and it was joined by Sotomayor, Kagan, and Stevens, this was a classic 5-4 case, right? The hard right 5 versus the rational 4, and 2 of whom are Republicans. And Breyer makes the point that now, with this case settled this way, since Concepcion, if I'm pronouncing that right, was only suing AT&T for $33.
Right.
What lawyer? But AT&T had screwed millions of people out of that $33, so they were suing on behalf of those millions of people, which is what's called a class action lawsuit. That what lawyer in his right mind is going to take a case for $33?
Right.
Now?
Right. Well, the whole purpose of class action, if you go back and look at the history, Tom, it was to solve this very problem. The problem being that you could have a corporation that would engage in really almost criminal conduct. They would defraud people. They'd have all types of scams and schemes to take people's money at $50 a shot, at $100 a shot, at $200 a shot, knowing, before we had class action law in this country, knowing that there was really nothing individually these people could do. So they actually would do the calculations. They would say, okay, listen, if we defraud 1 million people for $30, let's say, we know what the statistics are on who's going to really bring a case. First of all, who's going to represent them? What lawyer is going to say, yeah, I'm going to spend $10,000 to represent you for $30? It's impossible.
It's like the car companies making that decision that they'd save $3.50 per
Pinto.
car.
Yeah, it's
the Pinto case. Yeah.
Same analysis, Tom.
How many people will die?
Yeah, and they understood, let's do the analysis. And so before class actions, that's how this conduct would take place. Now, you have, just a repeat of that, this is headed in the same direction. We're talking now about a commercial issue with AT&T, but with the reasoning that comes out of Scalia and comes out of Thomas, Alito, and Roberts, we understand where this is going. That what they want to do is they want to have a broad-based attack on all class actions. The idea of arbitration is this. Arbitration doesn't work for consumers, Tom, because what they do is they control the politics of who's on the arbitration panel. They stack the panel with industry hacks. Matter of fact, they have a whole methodology, would take a long time to describe, but the methodology is how do you move somebody from industry to an arbitration panel and vice versa.
Pap, is that why all the credit card contracts and things always have an arbitration clause?
Oh, yeah. Yeah, that is the new way of doing business. And now we're going to start seeing arbitration used across the board. But listen, here's the real problem, Tom. The real problem is, compare this court: Thomas, Scalia, Roberts, Alito. Take a look at history. Louis Brandeis, John Marshall, Oliver Wendell Holmes, William Brennan. Those people aren't really around anymore on this court. There's some bright lights, but we have a court that is really an extension of politics. If you take a look, if you understand Scalia, like I understand him, or Thomas or Alito, if you really understand their background, they never distinguished themselves. They were always an extension of corporate hacks. That's what they were. They were a tool for corporate America. But the problem is this is just one sign of what's happening. Karl Rove, if you recall, 20 years ago, said what we have to do in order to change this society in a way that we're comfortable with, that is where corporate America is in control, we have to do something about the courts. And what he meant was we have to stack the courts. We have to have the Thomases and the Alitos and the Scalias. And so they've succeeded, Tom. While we've been paying attention to things like races, Senate races and congressional races, they have quietly been stacking the court.
It's the Federalist Society.
Exactly. With the Federalist Society. It's simply an extension of the Ayn Rand concept of corporate America. So, and they've succeeded. The bad news is, as we sit here and speak, Obama still hasn't filled 120 vacancies that he could fill to try to reverse this somewhat. And I don't buy into the argument that he hasn't been able to do it because there's just too much resistance. There's always resistance. As a matter of fact, he's made no recess appointments to change all this.
Right.
So it all begins from the trial court. They've stacked the trial court. Then you go to the appellate court. They've stacked the appellate court. And then you go to the Supreme Court, and they've stacked the Supreme Court to the point of 70% of all decisions that come through that court system are made by ridiculously conservative judges, to where there's no real fine line analysis. I mean, geez, you read these opinions and you go, it was written by some clerk that was given orders on how to make the decision.
Right, and it came out of ERIC or something, one of these right-wing think tanks.
Right, that's exactly right.
And frankly, I think a lot of us are still trying to figure out why it is that Obama broke tradition and didn't ask all of the federal prosecutors who were appointed by Bush to voluntarily quit their jobs when he came into office so he could replace them with Democrats. Down in Alabama, you got the woman going after Siegelman, Laura Canary, she's still there. In any case, the bottom line question here, we're talking with Mike Papantonio, co-host of Ring of Fire radio show, an attorney, ringofireradio.com, and a guy who knows this stuff really well. Is this case, first of all, am I pronouncing it right? Is it AT&T versus Concepcion?
Yes, it is.
Okay. Is this case the end of class action law, or just with regard to arbitration? Or, I mean, where are we? We just have 1 minute, Pat.
Well, okay. Right now, it's just arbitration. This is a very aggressive court that wants to extend that across the board. They want to give corporate America a free ride to defraud and to do marginally criminal conduct and get away with it. I mean, that's where this is at. There's no nicer way to put it, Tom. That's exactly what's happening. Scalia's made it very clear he's a corporatist. So is Thomas, so is Alito, and so is Roberts. These guys know exactly what they're doing. They're deconstructing the civil justice process in America.
Yeah, this is... Marbury versus Madison. I'm still fighting that one. The court should not have these rights. Right. They were not given them in the Constitution. But in any case, so this is the beginning of the end. And although, do you see another case in the pipeline that has to do with not just arbitration but regular lawsuits?
Well, yes, there are. There's some preemption cases that we're going to be looking at soon that they're looking at. And every time they get the chance to say that it depends on what they want. If Scalia wants a states' right issue, then he says states have rights. If he doesn't want that, he said the feds have the rights. It's a moving target.
It's all about the politics, ultimately, at the end of the day.
Right.
And Thomas's wife, I mean, working next door here at the Heritage Foundation.
What an aberration.
Incredible. Okay, Mike Papantonio, attorney, co-host of the Ring of Fire radio show, ringofireradio.com. Check it out. Pap, thanks so much for being with us today.
Thank you, Tom.
Good talking with you.